Hello and a very warm welcome. Thanks for tuning in to CNN News 18. I'm Kritsween Walia. Let's talk about the latest that's come in the Pune Porsche car crash case. Remember, the Bombay High Court has granted bail to the juvenile. He will now be staying with us live this afternoon. Mr. Ashutosh, you've been fighting this case for the juvenile and a relief of sorts coming in for him, but a lot of disappointment in the victim's family, everybody who was fighting this case for the victims. Tell us about a case a little bit and on what grounds has bail been granted to the accused juvenile.
And now, even when the order was passed, the police, if they wanted any sort of changes in that bail order, they could have challenged it before the higher court. But in this case, they had not challenged it. Rather, they had filed an application before the Juvenile Justice Board to make amendment in the bail order. And then this, juvenile was sent to the remand home, And so that is what has been considered by the High Court as objectionable. Because once the bail has been granted by the Juvenile Justice Board, there is no any other law by which you can amend your own law, and even after the juvenile who has been granted bail, then you will send him back to the remand home or anything like that. So this is what has been considered by the court, and this juvenile's aunt, she filed as a petitioner, as a writ petition for habeas corpus, and she claimed that the arrest is not proper. This is something illegal detention, she claimed, and the court considered it that it has not been done in a proper manner. Now, the second factor here is that, as we know, that even the father has been accused, and another FIR was, also registered. And in this FIR also, if we see like Section 75 of the Juvenile Justice Act was added, whereby the parent was also made accused. So it is double jeopardy also, because on one hand, when you consider the accused as a juvenile, and you want to arrest the father because father was equally responsible as you are claiming as a police official. So, considering it to be a double jeopardy, because you cannot punish both of them for the same alleged offense. So that was also, something which the High Court did not find it to be in consistence with the existing laws. So considering all these aspects, and also the psychological condition of the child, because Juvenile Justice Act was framed for these purposes only. So whether the crime is heinous or minor, whatever it is, but a juvenile has to be treated as a juvenile, and it has to be seen that his psychological impact should not be in such a way that he becomes any hardened criminals in future or anything like that. So it is that a juvenile has to be given proper psychological treatment also, and at the same time he has to understand what he has done, and accordingly the High Court considered this detention.
That the Pune police was not able to present a watertight enough case. Is that right?
First of all, when the FIR was registered, initially the section was 304A. 304A is basically when a death is caused by negligence by any accused. So 304A, the punishment is like 2 years imprisonment. And this 304A is basically a bailable offense. So when this matter went to the court, to the Juvenile Justice Board, to decide the bail. So though Juvenile Justice Board was had no other option also, it was constrained to grant the bail. And once the bail was granted, instead of challenging that order by the police in the higher court, they filed an application before the same court that, there is outcry and, he should be sent to the detention center for his benefit or whatever it is. And then he was sent to the detention center. So this was basically, objected by the High Court in this case. The High Court clearly said that you should have challenged this order. How have you... there is no any provision of law to detain anybody who has already been granted bail, unless and until the higher court, stays that release of the accused. So this is what was observed by the High Court today.
Because many have come out to raise questions with the Pune police, and given the sensitivity around this case, that's likely to happen. But those who've raised an objection today, those who say that, the case should have been stronger, that there are so many details that came out in public domain that made things amply clear on who was to be blamed really. They've come out to say this is exactly a repeat of what happened in the juvenile court.
No, see, I feel that there has to be rule of law. There are laws already framed. If somebody is accused of, committing any crime, so that person has to be tried as per the law. And here, and as I said, that, the police have already arrested the bar management and others under Section 77 of the Juvenile Justice Act for serving anything which is not allowed under the law to serve to any juvenile, which is already under investigation. Then the police has also arrested the father by implicating Section 75 of the Juvenile Justice Act, that he was the parent and he had the role to take care of the child. So in that case, then see, either the child has to be treated as a child or as an adult. When you treat him as an adult, then there is no point of arresting anybody else, because then the child, when he is major, he has his own decisions. He can drive, he can, take whatever decisions for his own cause. But here, since the police has also implicated the others, and have treated this minor as a minor only, so there cannot be double jeopardy. That now since we have to arrest the father, let's treat him as a minor, and when we have to release the child, then let's try treating him as an adult. So both the things cannot be possible at the same time. This is what I think was objectionable to the High Court as well.
Okay, whether or not there are any other legal developments, only time will tell. Mr. Shrivastava, many thanks for speaking to us here on CNN News 18. With that.